In our previous lecture, already we have discussed about the exact meaning and those two vast principles and general principles involved in law of insurance, and that first one was regarding contract of indemnity, and the second one is relating to utmost good faith. And now we'll discuss regarding the third most important general principle involved in an insurance contract, and that is the insurable interest. So insurable interest means some propriety or pecuniary monetary interest. A person is said to have an insurable interest when he is so situated with regard to the thing insured that he would have benefit from its existence and loss from its destruction. In every contract of insurance, the insured must have an insurable interest in the object or the subject matter or the life insured. For example, a person has an insurable interest in a factory owned by him. If one exports goods to a foreign country, he has insurable interest in them. Similarly, a creditor has insurable interest in the life of his debtor to the extent of his debt. If there is no insurable interest, there can be no insurance. So, we found certain essential elements and requirements in regard to insurable interest. So, the first one is the very subject matter on which having insurable interest, and that subject matter must exist on in the form of property or certain rights or interest or on the life or potential liabilities. And also there must be a relationship between the policyholder and the very said subject matter, and that must be recognized by law, which should create a legal relationship. So also it would create a financial relationship between the policyholder and the subject matter. So, in that regard, we would like to discuss the provisions of Section 7 of Indian Marine Insurance Act of 1963, which provide in particular a person is interested in a marine adventure when he stands in any legal or equitable relation to the adventure or to any insurable property at risk therein, in consequence of which he may benefit by the safety or due arrival of insurable property, or may be prejudiced by its loss or by damage thereto, or by the detention thereof, which may incur liability in respect thereof. So, in that connection, we would like to discuss one important leading case, and that is in relation to Reliance General Insurance versus Shalu Sharma and others, which was decided in 2018, where it was held that the amount to be deposited shall be released to the respondent forthwith. The appellant shall deposit the balance computed in terms of the present judgment within a period of 8 weeks before the tribunal will shall be disbursed to the claimants upon due verification, and if the amount withdrawn by the claimants in term of the order of this court dated 12th August 2016 exceeds the amount to which they are entitled under the present judgment, no recoveries shall be made. The appeal is accordingly disposed of. There shall be no order as to the very cost, and this particular important leading case in relating to insurable interest, so a contract of insurance entered into without any insurable interest is a wagering agreement and thus void as provided under the Indian Contract Act of 1872. It is the existence of insurable interest in a contract of insurance that distinguishes it from a mere wager or gambling. The insurable interest must be a pecuniary interest. A purely sentimental interest would not be enough. So, we have touched the third most important general principle involving insurance contract is that insurable interest. Now we'll go to the fourth general principle involved in an insurance contract is causa proxima. So it mostly applicable in case of marine and fire insurance. We have the principle of causa maxima, the proximate cause when a damage has resulted due to two or more causes. We have to look to the proximate or the nearest cause of damage, although the damage might not have taken place without the remote cause. Thus, in the event of the loss, it is proximate and not the remote cause that is to be looked into. If the cause of the loss is a peril insured against, the insured can recover, otherwise not. And for that, we would like to discuss an example in relating to the very general principle of causa proxima. So, in a cargo of sugar being shipped in insured against sea peril, certain rats make holes into the bottom of the ship, where from the sea water enters the ship, thereby destroying the whole cargo. The remote cause in this case is rats, which is not a peril insured against, but the proximate cause is sea water, which is a peril insured against, and thus the loss will be recoverable. And in that connection, would like to discuss one important English leading case decided by the Queen's Bench Division in 1899, and that is Pink versus Fleming, where Lord Ishire observed the question, which is the causa proxima of a loss, can only arise where there has been a succession of causes. When a result has been brought about by two causes, you must in insurance law look to the nearest cause. although the result would no doubt not have happened without the remote cause. So, in the above case, the ship collided with another ship, resulting in delay and mishandling of cargo of oranges, which deteriorated. So, the Queen's Bench Division held that the damage to oranges was not direct result of collision, the peril ensured against, but of delay and mishandling. And as these causes were not insured against, so the insured could not recover the damage and loss caused to him. And in that connection, we would like to discuss one of the important leading case of recent time, and that is relating to Reliance General Insurance versus Salu Sharma and others, where it was held that the amount to be deposited shall be released to the respondent forthwith. The appellant shall deposit the balance computed in terms of the present judgment within a period of 8 weeks before the tribunal shall be disbursed to the claimants upon due verification. If the amount withdrawn by the claimants in term of the order of this court dated 12th August 2016 exceeds the amount to which they are entitled under the present judgment to recovery shall be made. The appeal is accordingly disposed of. There shall be no order as to the very cost. So, in that regard, also, we found a very discussion relating to the very cause of the principle, and that is causa proxima, and where exactly we found that as the very principle is involved as such, it would lead to exactly decided by the principle of causa proxima, and that is exactly relating to this important leading case. So now we'll go to the another most important principle involving insurance contract, and that is mitigation of loss. So it is another principle of insurance, and that is mitigation of loss by the insured. In the event of mishap, the insured must act as though he was uninsured. That is, he must take all those measures to minimize the loss that he would have taken if the properties were uninsured. Notice that the law only expects a reasonable effort to save the properties and not that he is bound to do it at the risk of his own life. So, the very principle that involves in this particular relating to mitigation of loss, which exactly means minimization of loss. So, in that regards, we would like to discuss that exactly mitigation means to minimize the degree of any loss or harm, and in insurance contract various clauses and conditions are specified so as to ensure minimum losses to the insurer. The principle states that insured must take all the necessary steps to minimize the loss. And in that regards, we have to discuss one important leading case, and that is relating to Redpath Industries Ltd versus Cisco. So, it is well established that the party who suffers damages as a result of a breach of contract has a duty to mitigate those damages. That is to say, that the wrongdoer cannot be called upon to pay for avoidable losses in the quantum of damages payable to the injured party. So, in that connection, already we have found another important leading case, and that also we have discussed as such. And in that case, we would like to discuss another important principle involving the insurance contract, and that is the risk must be attached. So, in that connection, we would like to discuss the very principle is that a contract of insurance can be enforced only if the risk has been attached. The insurer receives the premium in a contract of insurance for running a certain risk, and if the risk is not run, the consideration fails, and therefore the premium received by the insurer must be returned. It is so even where the cause of the risk being not run in the fault will or pleasure of the assured. So, in that connection also, we have discussed one important leading case, and that is the leading case relating to Redpath Industries Ltd versus Cisco, that already we have discussed, and now we'll go to the next principle that involved in every insurance contract, and that is the principle of subrogation. So, the principle of subrogation is a corollary to the principle of indemnity, and therefore applies only to fire and marine insurance. Subrogation is the right of the insurers to enforce for their own benefit all the rights and remedies which the insured possesses against third parties in respect of the subject matter which is being insured. Subrogation is thus the substitution of one person in place of another in relation to the claim, its rights, remedies, or securities after satisfying the claim of the insured. The insurer stand in his place. So, in that connection, we could like to discuss one important decision delivered by the Court of Appeal, and that is Simpson versus Thompson. So, where two ships, X and Y belonging to the same person, came into collision, the insurers of ship X indemnified the owner and then sued him as owner of the ship Y for negligence, claiming the amount they had paid in respect of ship X. And it was held by the Court of Appeal that they could not recover, as both vessels belong to one and the same person. And since a person cannot sue himself, no remedy passed to the underwriter. And in that regard, in relation to the very principle of subrogation, would like to discuss another important leading case, and that is US Airways Inc. versus McChudden in 2013. So, where in 2013 the USA Supreme Court held that the very principles of subrogation are extension of outcome of principle of indemnity, and it arises only after the payment of the claim, arises only after the payment of the claim, and also ensured to provide all necessary assistance and the very right to sue the third party. So, in this case, in particular, the Supreme Court of United States of America